My name is Gautam Raj. I am currently pursuing LLB fourth semester at the Central University of Haryana. To bring my presentation, I will discuss five important cases under the Copyright Act 1957, two decided by the Supreme Court of India and three decided by the Rajasthan High Court. Case number 1, Chowki Dhani versus Chowki Dhani Resort Private Limited. Fact of the case: in Chowki Dhani versus Chowki Dhani Resort Private Limited, the plaintiff, a Jaipur-based hospitality group, initiated a civil suit against the defendant who was running a similar themed resort under the name Chowki Dhani in Rajkot, Gujarat. The plaintiff claimed to be the original user of the trade name Chowki Dhani since 1990 and had applied for trademark registration in 2002. Throughout, the copyright in the logo was not registered. The plaintiff asserted substance of right in the artistic work, allying despite similarity, it filed a passing of action in Jaipur. The defendant challenged the territorial jurisdiction, asserting that the business and registered office were located in Rajkot. There are two legal issues. First, whether unregistered artistic work, including logo and visual element, qualified for protection under Section 2C of the Copyright Act 1957, sufficient to sustain a passing of action. Issue number 2, whether the plaintiff can invoke Section 62 of the Copyright Act 1957 to establish territorial jurisdiction in Jaipur, despite the absence of registration and substantive uh, in linkage to the cause of action. Judgment of the case: the Rajasthan High Court ruled that in the absence of registered intellectual property right, jurisdiction must be governed by Section 20 of CPC. The plaintiff filed to demonstrate any part of the cause of action arising in Jaipur. The court held that mere online presence or reputation is insufficient to invoke jurisdiction. It ordered the return of the plaintiff for proper filing before the competent court in Rajkot, Gujarat. Critical analysis of the case: the court judgment upheld procedural rigor but lacked engagement with international copyright norms under the Berne Convention and TRIPS Agreement. It also did not consider the impact of digital presence and a cross-border accessibility, which could have involved Indian IPR law in the digital era. Case number 2, Paresh Ajit Kumar Kapoor and ORS versus Tomar Enterprises and ORS. Fact of the case: in Paresh Ajit Kumar Kapoor and ORS versus Tomar Enterprises and ORS, the plaintiff engaged in the design and sale of air cooler, filed a suit under Section 22 of the Design Act 2000, alleging that the defendant had fraudulently imitated their registered cooler design. The plaintiff obtained design registration in 2010, valid until 2025, and claimed the defendant were manufactured nearly identical coolers. The suit was filed in Jaipur along with an application for interim injunction. The defendant contested the originally of plaintiff design, claimed their own registration 2018 and 19, and filed for cancellation proceeding before controller. There are two legal issues in this case. There are two legal issues where visual imitation of a registered design qualifies a design piracy under Section 22 of the Design Act, even if minor cosmetic change are made. Issue number 2, whether defendant independent registration and claim of prior public domain use can neglect infringement and injunction relief. Judgment of the case: the Rajasthan High Court upheld the plaintiff claim and granted interim injunction. It held that defendant coolers were a fraudulent imitation based on visual similarity, regardless of minor difference. The court applied the I appeal test, affirming that the plaintiff registered design remaining valid until officially cancelled and any interim violation Section 22 of the Design Act. Critical analysis of this case, in my perspective, the court approach effectively allied design protection bill copyright principle by emphasizing originality and visible identity while affirming the right of design holder. The judgment did not delve into whether double protection under the Copyright Act was available. It also left unresolved the question of overlap with public domain element. Nonetheless, the ruling reinforced a strong judicial protection for artistic components in industrial design. Case number 3, Aadhaar Product Private Limited versus Lotus Organic Care and ORS. Fact of the case, in Aadhaar Product Private Limited versus Lotus Organic Care and ORS, the applicant, a detergent manufacturer, filed a suit seeking a permanent injunction against the defendant for allegedly copying the packaging and label design of its product. Decided the applicant had used and registered its artistic packaging under the Copyright Act 1957. Since 2006, the defendant launched a product called Delight, Delite, with similar color, layout, and overall trade dress, alleging copyright infringement and passing off. The plaintiff sought interim relief, which was designed by the trial court, promoting their appeal before the Rajasthan High Court. Legal issues in this case, there are two legal issues. First, whether packaging and trade dress registered under the Copyright Act qualify a artistic work protected from visible imitation. Issue number 2, whether interim injunction is justified where prima facie copyright infringement and market confusion are alleged. Judgment of the case, the Rajasthan High Court declined the grant interim relief upholding the trial court order. It found that both parties had long-standing use of their respective packaging and the factual dispute regarding originality, confusion, and design. Similarity required a full trial. The court held that denial of interim injunction was not preserved and directed the trial court to conclude the main suit within 6 months. Critical analysis of this case is my perspective. The judgment highlighted the complexity of copyright protection is product, packaging, particularly bare design, reasonable common industry, artistic. Despite the plaintiff registration, the court preferred a caution fact-driven approach. While this ensures procedural fairness, it can label original creator vulnerable to commercial harm during litigation. The decision underscores the judiciary emphasizing on trial stage resolution over interim enforcement in contested if IP cases. Case number 4, Nandini Deluxe versus Karnataka Cooperative Milk Producer Federation Limited. Fact of the case, Nandini Deluxe, a restaurant chain, sued trademark registration of Nandini, Nandhini, along with a logo across various food categories excluding milk. The respondent, Karnataka Cooperative Milk Producer Federation, opposed it, citing despite similarity of their long-standing dairy brand, Nandini, Nandini. The applicant argued its logo was original and registered under the Copyright Act 1957. While the deputy registrar allowed partial registration, the IPAB and High Court received it, promoting an appeal to the Supreme Court. In this case, there are two legal issues. Whether copyright registered logo qualify a artistic work under Section 2C of the Copyright Act. Issue number 2, whether distinct visible artistic element can override phonic similarity in trademark dispute. This judgment of the case, the Supreme Court held that although the marks Nandini and Nandhini were phenometrically similar, that the visible and Contextual difference, especially in logo design, prevented confusion. It found that the applicant logo registered under the Copyright Act was sufficiently distinct and had been used honestly in unrelated codes. The code allowed the applicant trademark registration, including milk and milk product. Critical analysis of this case, this ruling clarified that copyright is logos given enforceable protection independent of trademark similarity, particularly when the artistic elements are original and visibly different. The court rightly emphasized that phonic reasonable is not enough to deny registration if the artistic work and businesses filed are distinct. However, it did not explore how copyright is logos interact with the well-known doctrine. Still, the judgment reinforced that bona fide copyright registered logo offer a strong defense is IP dispute across unrelated market. Case number 5. BN Firoz versus the state of Kerala and ORS. Fact of the case: VN Firoz, an independent developer, created software for the Kerala government's FRIENDS Friends e-governance project initially piloted in 2000. The government later expanded the project and entered into an MOU with Firoz of continued support. Dispute arose where software components were allegedly transferred to third parties. Firoz applied for copyright registration, which was denied due to a civil suit over ownership. The Kerala government then declared the software a protected system under Section 70, Clause 1 of the IT Act, promoting Firoz to challenge the notification and claim copyright under the Copyright Act 1957. In this case, I will identify there are three legal issues. Number one, whether software developed in government project constitute government work under Section 2K. Issue number two, whether an independent developer can claim authorship under Section 7. Issue number 3, whether MOU terms override default copyright ownership rule. Judgment of the case: the Supreme Court held that Firoz was not the first owner, as the software was commissioned by Microsoft and developed under government supervision. Clause 10 of the MOU clearly vested IP right in the government. The court upheld the protected system notification and ruled that the copyright belonged to the state under Section 2K and Section 17D. Critical analysis of the case: in my perspective, the judgment highlighted the primacy of contractual terms in public-private tech project and confers that government work override individual ownership claimed. While the court harmonized the IT and Copyright Act, it could have elaborated on the role of private developers in a state-led innovation. This rule reinforced a state ownership in commissioned software, even where individual developer कंटिन्यूड सिग्निफिकेंटली। थैंक यू। हमारा लैपटॉप है और अभी जो प्रेजेंट किए टॉपिक ये उसका पीपीटी है, आप देख सकते हैं 5 केस इसमें है जो कि पहले प्रेजेंट कर चुके हैं। धन्यवाद, बाय बाय।